The program today is purely the first phase of what will be a continuous program that we've committed ourselves to as the Law Society of South Africa. We will have more training, more workshops. There will be videos, etc., via our website. Frequently asked questions. It will be an interactive program on our website to deal with compliance with anti-money laundering and counter-terrorist financing. We'd like to thank you all for making your time, and especially one of our other speakers who's here present with us is Ashley from the Financial Intelligence Center, and we've got one of the other panelists, Kirsten Paula. She was live at the other previous session, but she has to do the session online. She was unavailable to do it in person. And for all of you that came today, we'd like to apologize for the fact that you had a shuttle from Killarney Mall to the venue. We forgot to make arrangements with the school where you could park across the road. So thank you very much once again. I'd like to apologize for our president of the Law Society of South Africa, Ms. Mabiyeng Lenyai. She's going to try to join later on the virtual session, but on her behalf, I'd like to thank all practitioners who comply, and we'd like to encourage those that are not complying to please comply. I know Stephen won't talk about it, but I always get the complaints about compliance fatigue. Unfortunately, it's the nature of the work of attorneys in terms of the critical work you do that compliance is a big issue. So thank you very much.
Good afternoon, ladies and gentlemen. I've got the honor and privilege of introducing Dr. Moniat. He is the acting DG of National Treasury, and National Treasury, as you all will have been seeing in the media, they have been actively trying to promote new legislation to help offset and avoid this potential grey listing. And I know that a lot of the experts in Teledex and many other analysts have indicated that it's highly likely that we will be grey listed. But what I can tell you is National Treasury are doing their utmost to try and avoid that grey listing. But instead of me speaking about what National Treasury is doing, let me hand over to the expert himself. So Dr. Moniat, great to have you here and welcome. Thank you.
Thank you, and especially a big thank you for giving me a doctorate, since up to before Mr. Pillay spoke and yourself, I didn't have any doctorate. So please, I'm plain Mr. and I don't have a doctorate. I don't want to be accused of making false claims here. No, but thank you for the opportunity. I think this discussion is really an important discussion, and I'm happy to take questions as well. So, I think let me just briefly explain. You know, South Africa after 1994. I think with Ministers Dala Umar, and who was the Minister of Justice, as many of you may recall, and Trevor Manuel, kind of led the initiative to get South Africa to sign up on various protocols, like the UN Code Against Corruption. I don't know if I got the name right, but it's called ANCOC. But also then facilitated that South Africa joins FATF, which is actually short for Financial Action Task Force, which is a body today of about 39 member countries. And we are the only African member of that. But all the African countries and other countries are members through regional associations as well, who are observers there. And FATF sets, you know, so this was one of the first early decisions taken under President Mandela for South Africa to get the best standards. And let me say, though I wasn't involved at the time on this particular initiative, I know that the banks, for example, who were seen as the primary sector to regulate, protesting quite strongly about why they needed to do your customer due diligence, how costly it was, and it is quite costly. Of course, in more popular terms, we call it know your customer. And if you just follow, you'll see that banks have actually opened themselves up internationally to huge fines when they're not seen to meet standards. So from resisting it, certainly now when people understand the consequences of grey listing because the world has become tougher on these standards, that even the banks themselves would beg us if, let's say, we refuse to do money laundering, we didn't have an anti-money laundering and we didn't have a regulator, they would really pressurize government to please regulate them. Because if we don't regulate them, they face fines from the US, the UK, the European and other regulators for not meeting minimum standards on customer due diligence. And so for other countries to know that South Africa has got regulators who are as strict as their regulators in enforcing these standards actually makes life much easier for our banks to function. So in the banking sector, not only from initially resisting to, that's around 2001, 2 when the legislation was going through, banks have actually realized that this has become so critical for their for them to do business that not having it will actually set them back and expose them to huge risk internationally. And as you know, your major banks need to certainly have correspondent banking relationships. And by the way, even if they weren't blocked off, it would be much, much more expensive if they seem to be high risk. So in the banking sector, this is settled. And let me say, you know, as you know, we had state capture in South Africa, and the Zondo Commission has outlined quite meticulously specific incidents, what happened. And certainly, for example, when the banks closed down the accounts of the Gupta family and their businesses, that's what I'm aware of, there was great resistance. But effectively, banks were saying that they cannot do business with this family, who clearly were the subject of, or the banks could see, with lots of suspicious transactions, to the point where they provided, the FIC had provided a certificate of 72 transactions to say, you know, this wasn't this nice family at the end of the road that's generous to everybody, but that their generosity clearly was driven by the fact that they were bribing people, that they were looting our major state-owned entities, their procurement budgets, and of course, being generous to lots of people who they thought could continue to facilitate the flow of these funds. And I asked myself, did our system work or not work? Did banks provide suspicious transaction records? Did the authorities act? Did the FIC alert the authorities when they received these suspicious transaction records? Did the authorities act on them? And clearly the answers were no, and largely they were no because under state capture, the prosecuting authorities were deliberately weakened not to do their job. And even if the FIC did do its work, the prosecuting authorities weren't going to act, and forcing banks, I believe, to act by closing accounts, which was the last and most drastic step that they would take. And this is the key point, that if the authorities fail to act, you're going to make the business environment more risky and actually bring huge costs to businesses and it raised the scope for greater corruption, fraud, and so on. So it's with that background, I think, that when we've done our mutual evaluation, the mutual evaluation is a peer review done by FATF, and every country does it every 7 to 10 years. And we've done it twice, in 2003 and in 2010. And this was our third one in 2019. But with COVID, they only released the results in 2021. And we got a terrible report. And in a sense, I think it reflects that the mutual evaluation was done at a time when we had just gotten past state capture. We had a new president appointed, President Ramaphosa, and he had, late in 2018, because of all kinds of legal actions that you had to deal with, like, you had a commissioner at SARS who we knew was actually facilitating the capture of SARS, but we had to go through a process before he could be dismissed by the president. And so even in 2019, when the mutual evaluation was done, we just had a new commissioners appointed, new head of the NPA, Ms. Batoy, Advocate Batoy. And so when they did the review of South Africa, I believe that they did it at a point where we were at our weakest. Now, I believe that we've made progress, and basically the way FATF assesses us is there are two aspects to it. There's 40 FATF standards. They call it 40 FATF recommendations. So they say you must do customer due diligence, measures in place, and so on. And we were deemed to fail on 20 of the 40. They normally have 4 categories, and we were in the last 2 categories, and that's like effectively a fail. And so we were asked to fix up 20 of the 40 recommendations by changing our legislation. Over and above that, FATF also has what's called 11 effectiveness outcomes, or immediate outcomes, which assesses us for effectiveness. Are we implementing the laws that we have? Are we doing what we should be doing? Are we getting the outcomes that our laws are designed to have? And on that one, we failed miserably. We failed in all 11 measures. And in 3 of them, we got the lowest category of no compliance at all. So we have the tough job then of fixing up all these 11 measures to show that we are effective, and fixing up the 20 out of 40 recommendations. Now we've got 2 bills in Parliament, the General Laws, Anti-Money Laundering and Combating of Terrorism, Financing of Terrorism Amendment Bill, just bill, no amendment, and the Poktatara Prevention of Organized Corruption ... Don't ask me, but I call it the Poktatara Bill, Amendment Bill, which are currently before the National Assembly. In fact, the National Assembly has just passed the General Bill. And between the 2 bills, I'm confident they'll be passed by the end of this year and enacted into law. We'll deal with 16 of the 20 recommendations. We'll have fixed that up. And then for the remaining 4, we have some regulations to issue, which I hope will be done and in effect by February, so that effectively South Africa will not only be not be a laggard, but will almost comply with all 40 standards, which, by the way, even many of the countries that are deemed to have top-class regulatory regimes on anti-money laundering, that they too haven't reached. And I think there's a good chance that we would be able to actually score really well on all 40 of the FATF recommendations, including the 20 we would deem to be weak. Unfortunately, that's not going to be enough to prevent grey listing. What we will have to do is to prove 11 outcomes that we've taken measures and we've made substantial progress. And I believe we have. So, yes, there were tests on, between the Hawks and the NPA. Have they investigated and started prosecuting highly connected people involved with state capture? Have they begun to act to seize the assets for Fisher unit? Have they begun to seize the proceeds from some of these crimes? So I think that we can demonstrate that, unlike 2019, yes, we're not perfect, yes, we got a long way to go, but that we will at least have achieved in what's called 3 of the immediate outcomes. We've made significant progress. And similarly, that we've made progress on terror financing and imposing the UN Security Council designations. But more importantly, that our regulatory system is also now up to speed. We will shortly be submitting a national risk assessment that's been developed by the agencies and a national strategy document, which will also help to get us through the effectiveness measures. So I'm not saying that we'll prevent grey chance that we will, difficult as it's going to be, but even if we get there, I think that the progress we made will be acknowledged, and it shouldn't take us long to get out of it. But can I say, we're not doing this to satisfy FATF. We're doing this to serve our own interests. One, if you want to be part of the international system, we've got to have those standards. But more importantly, if we want to deal with corruption and financial crimes and make sure that those funds are not diverted away from, say, service delivery, then it really is essentially in our own interest to do the changes that we've made and to build the capabilities that we're beginning to rebuild after those 9 wasted years. Now, that's just a broad sketch. And of course, it's going to be important to prevent grey listing because, as I said, your correspondent banks will either be less likely to deal with our banks or will become much more expensive given the higher risk, and they will be spending much more time on proving and dealing with due diligence measures against us. And that will affect not just the banking sector, excuse me, but it will begin to affect your insurance companies, but not just financial companies. It will certainly impact on other professions as well. Now, so we must do everything to prevent grey listing. But I want to deal now more specifically with how it comes and why I'm here today, okay? Is that if you look at legal practitioners, like the Zondo Commission found that there were a number of people who might not have been the primary persons driving the corruption and benefiting from the proceeds directly. But those who have embarked on it obviously hired lawyers, they hired accountants, they got involved with estate agents to try and buy properties. Maybe they bought fancy cars, they bought jewelry. That all these type of professional bodies and non-professional bodies, sectors, were also part of, were enablers. So you would get a legal company whose job was to defend the corrupt no matter what. They accepted funds to be paid that came from dubious sources, and really became part of the problem, or are part of the problem. And what the world is expecting and saying, yes, there may be confidentiality obviously between a lawyer and a client, but that should still not be an excuse for the legal firm to be abused, okay, or become a willing party to the corruption by enjoying the fruits of that corruption. Even if the funds were not there given directly and are not being hidden, say, in trust accounts, they would certainly have lucratively. There may be lawyers on tap. That all of those mechanisms not only impact or not only ensure that crime and corruption persists, but actually impacts very negatively on South Africa, not just reputationally, but economically and financially. And so it's in that context that I welcome this discussion today, this seminar, and I'm just outlining the broad approach and saying that the legal profession, I mean, when I started off talking about banks are the place where money is being held. And before the great, people used to think it's great that there's total bank secrecy. You had people who's, heads of state, Sani Abacha, who stole billions of dollars from Nigeria. And inevitably, anyone who engages in crime will almost always hide the money in another country. And they would look for Swiss banking accounts in the 90s and other countries. And there's a lot of dirty money that went to jurisdictions like London, as you see with some of the oligarchs in Russia and where their monies went, and they bought football teams and so on. So whilst the banking sector, clearly because it's all about money, is a prime target, however, there are other vehicles used as well: accountants, legal firms, or lawyers, or attorneys. And the question is, this has been internationally recognized, that the legal sector is very vulnerable to being abused by criminals, and also needs to adopt a risk-based approach to develop, document, maintain, and implement a risk management and compliance program, to also do some forms of customer due diligence, and to make sure that they are not being deliberately or secretly used to commit money laundering, to hide the proceeds of crime, or to assist terrorist financing in other countries. I mean, the world is kind of watching, so that we have to be not just be doing something, we need to be seen to be doing something. And I know that, there are big legal issues about, as I said, client confidentiality, and the relationship between an attorney and client is almost sacrosanct and important for fairness and for the functioning of our system. And I don't have the answer about how you prevent abuse, given what your core mandate is with your client to defend them. And the Constitution, the way I understand, does even make provision for that, if I'm not mistaken. I may be mistaken. But because I'm not a lawyer, so let me say that up front, I don't have any legal training. But it's going to be important, I think, for you as a profession to look at the abuse and to see what role you can play. Because at the end of the day, we must fight corruption on every front, trench by trench. We must expose those who assist corruption. We must prevent fraud, because that impacts also on ordinary people. And we need to make sure that no profession is abused to promote such, in a sense, evil objectives like defending to the death someone who steals money from the fiscus through the procurement system, because they impact very directly on the ability of the state to deliver. I think I've said more than a mouthful, and sort of, say that I hope you are going to ask of yourselves the uncomfortable questions about the profession, about the risks that it faces from criminal syndicates. And, if you take a step, let me end, before I end, say, if you take a step back, really the question that you have to face is that when you deal with crime today, you're not dealing with individuals only. When you deal with corruption, you are dealing with sophisticated criminal syndicates. You are dealing with people who are politically connected. You are dealing with people who, like we saw with state capture, worked and captured, people right at the top in terms of government. Now, and they make themselves so powerful that it's very hard to actually bring them to book, get them to account, to get the police to investigate, to get the prosecuting authorities to prosecute. That's what we found where we were in 2017, for example, and during those years of state capture. And those agencies all looked the other way. So if we go back to the Zondo Commission and the questions that it posed about dealing with the enablers of corruption and crime, I think you have to ask the difficult questions. Are there legal firms or are there colleagues of yours who are clearly, consistently part of or enabling criminal syndicates? And if we don't act, we shouldn't be surprised that we are almost seen to be a kind of, a mafia state where the syndicates clearly start ruling. They've got the politicians in their back pockets, they've got officials in their back pockets to do their bidding. And clearly, people on the ground suffer because their lot never improves because the state does not deliver for whatever reason. So, Chair, I'll stop there. I want to start by reminding you I ain't no doctor and don't want to live by any false pretenses, but I'm happy to take questions if you want me to do that. Thank you.
Okay, my name's Albert Murray and I'm an attorney. On your comment about most big international organized crime instances, the perpetrators like to hide the money in other countries. My question is, why then did Treasury, since 2003 up until today, ease exchange control to the point where today there is no more exchange control, to the point where the FIC will only start looking at an individual if that individual has transferred the equivalent of more than 10 million rand per year out of the country? Surely if it is a feature of organized crime to exit money out of the country, surely Treasury should enable stricter, effective exchange control measures, don't you think?
Good afternoon. My name is Greg. I am not an attorney. I am an accountant, and I'm on the front line of reporting suspicious transactions. We have since 2016 been regularly audited by the Gauteng Gambling Board for operations, We have, since 2016, had a few recommendations made to us, which we have carried out. And recently, just a few weeks ago, we completed our audit for the 2021 year, and we came out with flying colors, because we, or should I say my department and I, are continually striving to keep compliant. However, when we do report suspicious transactions, unfortunately, we have no response to know has there been any follow-up from FIC. We submit them on a regular basis, but we get no feedback. Now, if the people we are reporting are let loose, what is the point? Then why do we have to stick to all these regulations where you are requested to report but you get no feedback? Thank you.
Good afternoon, my name is Chris. Just on the 11 implementation issues that you were discussing, you were saying earlier that it would take us a short while to have those resolved. Could you just maybe clarify how long you think those issues will be sorted out?
Sorry, can you just clarify that question? I don't understand the question. I didn't get the question.
Okay, I do apologize. So you said earlier there's on the 40 recommendations, 20 were outstanding, 14 are currently will be addressed by current legislation that's before Parliament. But then you mentioned that from the implementation side, there are 11 issues that it needs to be addressed. But afterwards you said it will take us a short while to sort out those issues. Just from my point of view, I would like to know how long you think it will take to sort those 11 issues out.
You want me to start answering?
Yeah. Please, Mr. Momaniat.
Okay. So let me start with the first one. Yes, by their nature, with most who conduct corruption, certainly, and fraud, and like you see with drug syndicates, funds are transferred to another country to make it difficult for the authorities to recover the money. If you look at exchange controls actually didn't prevent such things either. Exchange controls are almost unique to South Africa, and they tended to be very, I think, a very antiquated system. We've not, in getting rid of exchange controls, we've replaced it by what I call more macroprudential measures and microprudential measures. So if a bank is doing, I mean, the only way to transfer funds is through banks. I know that there's many smaller players doing payment systems, but if you look at banks, they've got to do a customer due diligence, they've got to have comfort about the source of those funds, and certainly we can improve the system for banks to stop those funds from being transferred when they deem to be very suspicious, okay? You can have measures. But you've also got all these money transfer agencies that have developed, and I think there are weaknesses. And certainly it's been outlined in our mutual evaluation that we need to improve the quality of supervision there. I think that the issue and the amount you raise of 10 million, even if you are transferring 1 rand, if they deem to be suspicious, the institution needs to act, and we think that you can put in place better controls than exchange controls to deal with it. I think the bigger problem is whether we have exchange controls or not, the type of abuse you've seen. They hide under the banner of being normal transactions, and you don't want to begin to put undue delays on the payment mechanism between countries. I mean, there's a huge market, and we need to be careful how we regulate it. It needs to be regulated, but how it's regulated and how it functions. So exchange controls, I think phasing them away I don't think really makes us more or less exposed to corruption. But I think that we need to use better mechanisms to monitor and to prevent proceeds to flow out when they are clearly sourced illegally. And I think some institutions are doing it because they understand the mechanisms, but there are many lightly regulated transfer agencies which I think where the problem does reside. I'm not saying not only there, because a lot of the transfers you saw were done through banks, but they were done as legitimate transactions. So they clearly need to look at how they function. If you look at, and maybe linked to that is a second question, which is a very good question, that suspicious transaction records are submitted to the FIC, and there's no evidence that it leads to the arrest of people or to stopping the illegal activities. I think that's one of the frustrations we all have. We seem to take a very long time before we act. And the longer you delay on acting, obviously the more likely the money is not only able, well, actually leaves the country. And so whether you have exchange controls or not, if you don't act when there's red flags, then frankly, you'll never have a system that will be effective. And this, in fact, this is one of the frustrations I have. The FIC is not allowed to tell me what suspicious transaction records were provided during the Gupta years. And so I often ask them and say to them, you need to check whether, you did what you should have. And if you didn't, to fix up the problem. In fact, the Zondo Commission has actually asked, as one of their findings or recommendations, that there's a kind of process to assess how the FIC functioned during the years of state capture, whether it reported those. They don't say it as much, but my understanding is that the FIC should look at whether they received STRs, and if they did, what did they do about it, to whom did they report it, and to find a mechanism that, to the extent that the Hawks and others actually did anything about it, did they investigate, or did they just simply ignore it? Those, I think, still need to be done. Certainly the Zondo Commission doesn't seem to have gone into that detail, and it's actually one of its recommendations that that be done. And I see that as being an extremely important objective that needs to be still done. In the same way, by the way, in the same way that I feel that even when you look at what happened during state capture, that we have preventive mechanisms in terms of the PFMA. So I asked, there was a chair of the audit committee. What did they do during 2010 to 2018? There were internal controls. What did they do? There were auditors who saw nothing. Why did they see nothing? I think, just as I'm saying for the legal profession, these questions have to be asked. These questions still have to be asked of the auditors who were involved, of the financial professionals who were involved. And in fact, I would say that anyone who chaired audit committees and saw nothing doesn't deserve to be on any audit committee of any institution that wants an effective audit committee. So those are the kinds of questions we need to ask. But given the confidentiality around STRs, it's just frustrating even for the Treasury that we can't conduct this. But we hope that the FIC will put in place a system to look at it, because I think it's a real crime by itself if, when there are red flags, when there are STRs, that those who are given those don't act. I think that's criminal, and we need to fix that up. The third question on the recommendations, yes, the 20 out of 40 are easier to deal with because they relate to the legal framework, and by changing legislation, and to the extent that it's changed the right way, you can deal with that. But the 11 effectiveness measures, it's not, well, maybe some of it won't just be a short while, some of it might take longer, because we have to demonstrate to FATF that we've made substantial progress the last 2 years. So if you, as I said, if you look at the 11, 4 of the measures relate to prosecutions, investigations, asset forfeitures. 3 of them relate to terror finance, financing terrorism, financial sanctions, and 2, I think, relate to beneficial ownership. So you can see the 4 that relate to the criminal justice sector. 3 are really related to the area of those who investigate terrorism, and so it can be your intelligence agencies, and so that covers 7 of them. There's 1 that relates to just showing that we have an agreed national risk assessment and strategy that we are in the process of submitting, and that's been developed. So that should be easier to comply with now that it's almost done, which then leaves, that's 8.3. As I said, 1 or 2 relate to beneficial ownership, 1 or 2 relate to, do your regulators, your supervisors in the financial sector, your prudential authority, your financial sector conduct authority, do they use a risk-based approach when they supervise? And of course, in 1 of them, it's the legal profession, estate agents, jewelers, and so on are all included. So each of those sectors will, if they are regulated, and some, for example, jewelry, it's not a regulated industry. The issue is, to the extent that you are a regulated industry, how do you demonstrate that you too have the supervisors who oversee the legal profession? I don't know if you can call them supervisors, I mean, it's a council, that they too use a risk-based approach to deal with potential money laundering and abuse of terrorist financing, or whoever is doing that, the system has a higher possibility of identifying. So some of those things, certainly to be successful, might take a few years. But the issue is, can we demonstrate that we've made reasonable progress and the will is there to continue to make this progress?
Thank you very much, Mr. Momaniat, and we really appreciate you taking time out to address this seminar. It is important, and I did mention I will talk about a doctorate in one of my cases that I investigated. I investigated the chairman of one of the largest banks in Zambia who professed to hold a doctorate, and when I gave evidence against him in the Zambian High Court, I concluded my evidence and said to the judge, "My lord, everyone refers to this gentleman as doctor," and I'm not going to repeat his name now, but we have in our possession a letter from Harvard University which states that not only did this gentleman not study at Harvard, he certainly has no doctorate from Harvard. So with respect, as I can quote my boss, Michael Katz, we refer to him as Mr. and the name. So I'm very pleased that you disclaimed the doctorate up front, Mr. Momaniat. Thank you. But what I'm going to do in my talk now is I'm going to elaborate on some of the issues that Mr. Momaniat has touched on, and we're going to go through, just touching again on the grey listing. I'm more optimistic than many of the experts, and maybe I'm just more naive than the experts, but I still think that when I look at what we have done, we've passed these laws, and it's very exciting that just yesterday we had approval on the bills before Parliament. 19 October, the FIS amendments were published, and crypto assets are now under the supervision of the Financial Services Conduct Authority. And Mr. Mamoniat, you referred to the fact that if you want to transfer money at one of the banks, you have to answer countless questions, fill in forms, and explain who, what, why, when, how, etc. But the crypto people could transfer money all over the world in minutes without any supervision, without any questions. And that was a glaring money laundering gap that has been addressed. So that's one of the 40 that we've struck out. And in terms of the legislation, I think that was the easier part, even though that in itself was challenging. There's a lot of work that needs to be done to rebuild capacity within the Hawks, the DPCI, the NPA, but I am pleased that that process has started some time ago, and we have replaced some of the puppets that were there in, if I can respectfully just refer to the Zuma decade. And we've started to unravel that, but there is a lot of work to do. So I'm going to walk us through some of the shortcomings in terms of the FATF Mutual Evaluation Report. We refer to that as the MER. For those of you who are interested in this topic, the MER is a public document. It's out there. You can actually Google it. It's quite a lengthy document, and it goes into detail on the issues. And then what does this mean for lawyers is something that I will expand on. And then one of the things we are highlighting in the seminar is that the Law Society, the Financial Intelligence Center, all of these bodies are trying to issue as much guidance and support to the profession as possible. And my advice as a practitioner is just to say to everyone, the regulations are here. We need to have these risk management programs to address the money laundering risk. It is a fact. This is the way of the future, and it's the way of the world. So instead of opposing it, let's just get to grips with it, get on top of it, and make sure that we make anti-money laundering compliance top of mind within our own practices. We've got a panel discussion that will be taking place later, and we've got Ashley from the FIC, Ricardo will join me, and then we've got Kirsten who will join virtually. And we'll answer questions amongst ourselves, and then we'll hand over to the floor and to the online attendees to also pose questions. I am going to walk you through, and I think it's useful to actually walk you through a case study right now. What do? I'm the head of forensics at one of the law firms, E&S Africa, and we investigate fraud, corruption, money laundering cases. And in the work I do, I've acted for the Asset Forfeiture Unit on multiple matters. I've gone seizing assets of road accident fund lawyers, fraudsters, clergymen, all kinds of professions. We've gone and seized assets, and the one common denominator that we find each time is that there's multiple gatekeepers through whose hands these transactions have flowed. So if I give you an example, I was curator for the Asset Forfeiture Unit, appointed by the High Court to seize the assets of a cocaine smuggler in Milnerton. When we looked at this cocaine smuggler, he had no real income. He ran a flea market stall on Green Market Square. His declared income to SARS was 4,000 Rand a month. But when we looked at his asset profile, he had 4 properties, he had 3 cars. We seized the cars, we froze his bank accounts, we put in notices of the hold to the deeds office so he can't dispose of the assets. But the question is, estate agents took his cash, he bought these properties for cash, and they took his drug money without question. The lawyers did the conveyancing, and they took his money without question. The banks, I hope they issued their STRs, and they can continue with the transaction once they've issued the STR. What they did is they sent a financial advisor to go visit my cocaine smuggler because he deposited R1 million in cash with the bank, and they said to him, "Sir, we can see you've got loads of disposable income. we'd like to send you some investment advisor to talk to you about better investment opportunities. So what I wanted to do with the example was just to show everyone these are real things that happen all of the time, and lawyers are referred to in the FATF guidance as gatekeepers to corruption, and sometimes we refer to as facilitators of money laundering and corruption. And we have a role to play. We actually need to conduct ourselves ethically. When we can see that our clients are engaged in money laundering activities and there's lots of red flags, we have a duty to report these to the FIC. I'll also elaborate on the reporting statistics because the FIC did an assessment of the legal profession, and the result is the reporting, the volume of reports that have gone to the FIC from lawyers is dismally low. It means we're not reporting our clients when we see things going wrong, and we need to address that. So we as lawyers have a tangible role to play in helping government and our country to show the 11 that Mr. Momoniat was talking about, the success just in terms of statistics results. So we all have a role to play. I've done a whole lot of red flags in my slides, and what we've agreed with Tony and the Law Society is we'll publish them on the website, and I urge you to go through that and go through the guidances, because those guidelines have also got red flags. There are lots of red flags. And then I'll also just explain why PIPs and PEPs are so important. We've got politically influential persons, we've got politically exposed persons, you have domestic PEPs and you have international PEPs. And when you have corruption, and many of you will have seen this from the Zondo Commission, there's always invariably a PEP involved in the process, and the PEP is a current or former government official who is asked to influence or to facilitate some of the corrupt activities. So let's just have a quick look, and I'll work very quickly. The Financial Action Task Force report highlighted, the Mutual Evaluation report highlighted acute weaknesses in our AML and counter-financing of terrorism regime in South Africa. Their report was published in October 21, and in February of next year, they're going to announce the outcome of our response to the report. And so we've had quite a bit of time to work on our responses, and there are quick wins, which you heard from Mr. Momoniat about, but there's also longer-term enhancement of our judicial process that is going to take time. So rebuilding the NPA, you heard and you've seen the appointments, the changes all took place in 2019 already. But building capacity in the DPCI is going to take years. When we look at the criticisms, the Hawks do not have the expertise to analyze bank statements. They don't have forensic accountants. They don't have digital forensic experts. These are not skills that will be provided overnight. It's going to take a lot of time to build that type of capacity within the state. Mr. Momoniat already referred to our scorecard, but I'll just give you a detailed breakdown. We're only compliant with 3 of the 40 recommendations. We're largely compliant with 17. So that's our 20 out of 40, 50% score. We are partially compliant with 15 and non-compliant with 5 of the recommendations from FATF. So if I just summarize where, in my own words, are we falling short? We're not doing enough to investigate money laundering offenses. Our successes are not consistent with our risk profile. We've got a handful of money laundering prosecutions in the country, and we are regarded as a high money laundering risk jurisdiction globally. Law enforcement agencies do not understand money laundering and terrorist financing, and we've got to do more to identify terrorist financing. In South Africa, up until now, NPOs didn't have major supervision, and they didn't have detailed requirements when it comes to registration, who the NPO is acting on behalf of. And it is a fact that NPOs are abused globally to facilitate terrorist funding. ISIS and these institutions use NPOs. So you'll see that some of the proposed changes to legislation is really enhancing what we do with NPOs. And there's a lot of resistance because it does mean sports clubs, knitting clubs are all going to have to register and be under supervision, but it is in the greater good of the country, and we need to do this to show the world that we're not leaving holes for money launderers to work through. We have to better manage the KYC process, and this applies to our profession. We've got to know who we're dealing with, and we've got to have the program where we ask all the right questions. Ricardo will walk us through the materials that the Law Society has put at the disposal of the profession. There are checklists that you can complete, and there's a guidance to make it easier. And the guidance is short. So please refer to these documents and use it. We also have to identify ultimate beneficial owner, and you'll see there's changes to the Companies Act that is underway, and we're going to have enhanced requirements for disclosure of ultimate beneficial ownership. The challenge will be in building the databases and the registry, because CIPC and the Master's Office are going to have to create the ability to provide these platforms to do the screening. And we need more enforcement and convictions. I think just in terms of the enforcement, I've been particularly heartened by the arrests that have taken place recently. We all saw 2 weeks ago, 3 weeks ago, Mr. Coco and his cohorts arrested on the Eskom stuff. Prior to that, we saw some of the masterminds behind the Transnet stuff have been arrested. So the wheels of justice turn slowly, but they are now in motion. So I think from my perspective, we should be really pointing out to the FATF that we've enhanced our legislation. You can see our bodies are busy getting to grips with these rogues. So if we just run through quickly the main threats. So understanding and scale of money laundering vulnerabilities and threats from foreign predicates is limited. Terrorist financing risks are not being adequately addressed. The legislation will address some of it, but the proof will be in the pudding whether we actually get to enforcement. And then state capture was invaluable because it has exposed a lot of the corruption. But as Mr. Mamoniat highlighted, it put us in the spotlight at a time when we were at our weakest, and we regarded as a highly corrupt country at the moment because of the revelations in state capture. And state capture has made, the Zondo Commission has made extensive recommendations for significant enhancements in a number of areas. DPAs, deferred prosecution agreements, to encourage corporates to confess and cooperate, that's going to be invaluable. You've all seen the example shown by EOH, which came clean on the corruption, and last week there was an announcement they've paid back just under 200 million they've agreed to pay back to the Department of Water and Sanitation. I can't resist just sharing the story about the Minister of Water and Sanitation. You all know the story of her Aston Martin sports car that was in the garage under cover, and the electrician testified at the Zondo Commission. He was paid for by Bosasa to go and do electrical work at the house, and he saw this car under cover in the garage, and he said he couldn't resist peeking under the cover, and there was this Aston Martin. And the judge asked Minister Mokonyane, or former Minister Mokonyane, how did you pay for this car? Isn't the car a bit expensive? And she said, it was 3 bars, Judge. And he said, and how many of the 3 bars did you pay? No, I paid 1, Judge. And where did you get the other 2 bars? I got help from a friend. And the judge's next comment is, so did the friend happen to get work from the Department of Water and Sanitation? And she wasn't that clear in her answer. She said, well, I was here and they wanted to be here and I could help them to be here, and we need to empower and transform. And they helped me with 2 bars towards the Aston Martin. Sorry, I am digressing, and we've got a long program to still get through. So state capture, I think, put us under the spotlight. The other item that they highlighted is the FIC produces operational financial intelligence. They get these reports, they're a repository of information, and then they farm it out to the different bodies that have to investigate and deal with it, whether it's the commercial police, DPCI, SARS, etc. And they said that that system is working, but the law enforcement agencies don't have the skills to understand and investigate this properly and to trace criminal assets. They lack the skills and resources to proactively investigate money laundering and terrorist financing. And then they said, this comment I made earlier, we get a reasonable number of money laundering convictions, but it's nowhere near consistent with our profile. And they highlight that the state capture cases in particular have not been robustly pursued. We've had good results in pursuing confiscation of criminal proceeds, but not so much when it comes to state capture. And when we look at state capture, United States seized assets of the Guptas when they transferred funds to their nephews in New York 3 years ago. The UK seized funds when there were transfers from Dubai to London, and South Africa, we haven't seized anything. And that's the criticism. So we need to do more on that front. The use of cash is prevalent in South Africa. It's regarded as a high risk for money laundering, and including cross-border movements. And then we've only convicted one person in 20 years for terrorist financing. And they're saying when we look at the amount of terrorist activity coming through US Secret Service reports, etc., it's not consistent. There's more terrorism happening than we're getting to grips with. And law enforcement faces challenges regarding getting updated beneficial ownership details. I've highlighted the changes on the Companies Act. And then the area, bringing it closer to our profession. Most smaller financial institutions and designated non-financial businesses and professions are focused on compliance, not identifying and understanding money laundering risks. And there they single out lawyers, estate agents, and you heard from Mr. Momoniat, dealers in precious metal and stone, company service providers, as well as the virtual asset service providers, VASPs. You heard that we fixed the VASP problem. It's actually a vast problem. We also get criticized because we provide mutual legal assistance with international investigations, but the criticism is that we don't take these seriously. We're very slow at providing the cooperation to foreign jurisdictions when it comes to investigations, and we should be relying on them to a greater extent to provide info to us as well. And then targeted financial sanctions, we've had some success in implementing, but major improvements are needed. Those are some of the highlights of where we've fallen short, and I just wanted to put the context so you understand where we as a country find ourselves right now. And then we'll drill down into the legal profession. But before we go into the legal profession per se, we can look positively at Mauritius, because Mauritius had the same problems that we had. They were grey-listed in Feb 2020, and I was in Mauritius a few weeks ago with the Law Society there, and they're also trying to make sure that they educate members of the profession on having these robust risk management programs in place to detect and report. Because even though Mauritius got off the grey list in a record 20 months, they still have to show the enforcement of these laws. And when we look at why they were grey listed, they had the same problems as South Africa, but they acted quickly, they passed new laws, and they took a whole lot of measures to enhance. And if we look at Mauritius, they also had the problem with designated non-financial institutions such as lawyers, estate agents, and jewelry traders. They were flagged in the Mauritius MIR, Mutual Evaluation Report, for money laundering and terrorist financing activities. We've had state capture, and then we've had accounting failure after accounting failure. And we've been under observation. We've now got to show that we're doing enough. And I know Mr. Momoniat was not that confident that we'll get off it quickly. And the second piece of the second thought I want to leave with you is, if we end up on the grey list, government, the country, and all of the different sectors will have to mobilize to get us off that list quickly. No one has gotten off the list as quickly as Mauritius. 20 months is a record. It takes 3 to 5 years. The impact of the grey listing is estimated by experts and economists to cost us 1% of GDP, and it can go as high as 7% depending on how quickly we react. So this is massive. It's actually a devastating blow that we don't need as a country. Government is doing all it can by passing all of these new laws, and just to help Mr. Momoniat, that Protection of Constitutional Democracy Against Terrorism and Related Activities Amendment Bill, that's the full name of POCTATARA. And it's going to bring sweeping changes. And a lot of people are going to have more red tape, more bureaucracy when you want to register an NPO. When we want to onboard a client, we're going to have to take them through the CDD program robustly. Now, if we look at our profession, we are internationally recognized as vulnerable to being abused by criminals to launder the proceeds of crime. And we advise on creating legal entities, including shell companies, trusts. We provide conveyancing services. We provide client accounts. We allow clients to sometimes abuse our trust accounts, and we're potentially vulnerable to abuse in terms of money laundering. Litigators even get used to go and pursue fictitious debt to create a semblance of a reason for money to flow. And that example that I gave you around the cocaine smuggler, the same happened in the case I did in Zambia. There we had a chairman that was taking kickbacks, and he would take 10%. If your company needed financing, he would give you the 30 or 40 million, but 10% of what he gives you gets paid to a Geneva Swiss bank account. In terms of Section 42 of the FIC Act, attorneys as accountable institutions have to develop, document, maintain and implement a risk management and compliance program for anti-money laundering and counter-terrorist financing. So if you don't already have a program in place, please get one. You'll hear from Ashley, the FIC are going to be doing inspections, and you will need to show that you've appointed people to deal with this and that you've got a program and that it is functioning. And that supervision is important as well, because we've got to demonstrate to the FATF that the regulator is looking after our profession, and the FIC have that responsibility. In terms of our obligations as legal practitioners, we have to understand our AML and CFT obligations. We've got to understand our ethical obligations to our clients and to our requirements in terms of the program. And we've got to train our staff to be alert to the misuse of the lawyer and the law firm by criminals. And they must be able to identify complex transactions that could engage money laundering offenses. And the staff need to also know what our reporting obligations are. So if you see the red flags for money laundering, you know we've got to report. And you need to try and dissuade the client from doing things that are illegal. And in some cases, you may need to refuse to act. So we're going to have to turn away paying clients. And when they're telling you, I'm about to deposit R1 million in your trust account, it's not going to be that easy for you to walk away from a lucrative assignment. But that's what we have to do. So there's going to be a lot of ethical choices that we need to make. And then that customer due diligence is critical. I'm not going to go through the red flags, but we'll touch on some of those red flags in the Q&A discussion that we're going to have. And I think if I can just borrow stats from Ashley's report when they did the assessment of the legal profession, the annual average over the last 5 years is 2,393 suspicious threshold transaction reports and 232 STRs per annum over the last 5 years. Ashley will tell you later, I'm sure, that that is ridiculously low. It's not reflective of what is happening in the marketplace. We have to make sure we continuously educate ourselves and be vigilant, and if I can ask you to please use the tools that the Law Society has provided. Later on in the Q&A, we're going to talk about issues that we grapple with, and we invite you to pose questions to us. What do we do with small practices? What do you do if you can't afford to have a compliance team? I work for a big law firm. We've got a marketing team. We've got a compliance team. We've got teams for everything. I sometimes worry that sometimes we have more administrators than lawyers in our business. And the term I had for compliance, remember, we've got to comply with anti-money laundering, anti-terrorism, anti-sanctions. There's a lot of screening that we have to do on our clients. And some of it, you can just Google and you'll find if there's adverse information about your client or if your client has a dubious past. So do the homework. But with the volume of compliance, I always speak about this new disorder that the medical aids are still refusing to recognize. I call it CSD, compliance stress disorder. So you'll see in the slides, and if we just brush through them, there's red flags for transactions that are unusual and suspicious. There are red flags where the source of funds is unusual, where the method of payment is unusual, and repayment periods are short without explanations. There's a multitude of these red flags. There are geographical red flags. Sometimes you'll be asked to make payments to high-risk jurisdictions which have nothing to do with the transaction. Be suspicious of all of those, ask the questions, and if you don't get satisfactory answers, be mindful of your reporting obligation. So I'm going to go to the PEPs. I've done a lot of cases of corruption all across Africa, and some of the cases that I've investigated involve millions of US dollars. And the consultants who advise on getting government permits, getting approvals from state, getting trading rights, etc., sometimes those approvals have to come from a president's office or a senior minister of mining or finance. And the stuff that crosses my desk when we do these investigations are requests for money from ministers, from presidents. One of the letters I read was, my wife has developed an urgent condition. She needs an operation in Paris. I call on your company to sponsor her trip to Paris in the amount of 40,000 US dollars. And that's a request to a client who's setting up in that country. They don't want to say no, but if they do say yes, they're going to be in a corruption risk scenario. So the PEPs, on some of these consultants, came across one that helped a mining company set up, and it wasn't Glencore, another mining company. And the fee for the consultant was 10 million US dollars, and it was 2 million per milestone. 2 million for concession, 2 million for mining rights, 2 million for another approval, and so on. And when we look at the consultant, he was a former minister, he was a friend of the president, he came from the same tribe as the president, grew up together, and we've got no doubt that some of his 10 million was going to find its way back to the president. The reason I share the example is just to almost amplify the risk posed by politically exposed persons or politically influential persons. And many of you will know I testified twice at the Zondo Commission around corruption that we found with one of the IT companies, and there were payments to politically connected middlemen, these intermediaries. And sometimes those emails would read, my brother, we need your help. This tender was going in our favor, but for some other reason, the adjudication committee now seems to favor the opposition. They should have no idea of what's happening in the adjudication committee. And they go on to say that their price is 5% cheaper than ours. They shouldn't know what the competitor's pricing is. Can you help? If you can assist, there's a quick million for you. And I heard there's a term for a million. There's a quick butternut for you. And these are two prominent political figureheads, some of whom are still in office, and some have passed away. So that's why it's so important to highlight these PIPs and PEPs. And now let me just close. My concluding points is that the legal profession has to ensure that vulnerabilities in our area are mitigated and controlled to make sure that we're not a contributor to the money laundering risk. Use the guidance from the FIC and the LSSA to ensure that you develop, document and maintain a robust risk management compliance program. This RMCP is a requirement. You need to have it in place. We all have a role to play. Let's make sure that the profession is part of the solution, not part of the problem. Thank you, ladies and gentlemen. So let me introduce Ashley, and I'll allow Ashley to say a few words. Ashley is in charge of compliance at the FIC and awareness. And prior to that, she was a money laundering officer in a number of banks. She was also part of the evaluation committee for South Africa, and she's currently part of the Mutual Evaluation Committee evaluating, is it Indonesia? Ashley, have I done justice? And she is a qualified lawyer. No?
We're all getting promotions.
Okay. Okay, Ricardo, let me allow you to introduce yourself.
Hi, good day, everybody. My name is Ricardo Weingaard. I'm the Senior Legal Officer at the Law Society of South Africa. And I'm basically working with the Law Society's committees. We've got various specialist committees dealing with different fields of law, criminal law, environmental law, ethics. Yeah, there's about over 20 committees at the LSSA. This particular committee is focusing on compliance-related issues for the legal profession. And so as the LSSA, part of our mandate is also to support the legal profession. And in doing so, our aim and what we've been doing up until now is to provide practical tools for legal practitioners, knowing that there are over 13,000 either single or small practitioners in South Africa. The compliance-related obligations on legal practitioners are quite significant. We are patently aware of that. So part of the AML responsibilities entail compliance for organizations. So we are trying to do our best to facilitate compliance for legal practitioners, practicing legal practitioners in South Africa. So thank you.
Thank you, Ricardo. And if I can just add, we've got our online panelist, Kirsten Paulo, is a senior associate in the Banking and Finance Services Regulatory Practice at Bowmans. She's a financial services regulatory lawyer, and she specializes in all aspects of financial services and advises local and foreign clients on the content and implications of the FIC Act and other legislation, and she regularly assists clients with drafting of risk management and compliance programs in terms of FICA. Welcome, Ashley, and let's just check that the sound is working and you can hear and speak.
Hi, can you hear me clearly?
Yes, perfect. Thank you. Welcome.
Perfect. Thanks.
We're going to jump into a number of questions that I will be posing to the team, and then later on we'll open to the floor and to the online attendees to pose questions as well. So, Kirsten, I'll kick off with you. I know some of the questions we had was on the impact of grey listing, but I think with the talk I've given and the inputs from Mr. Mamoniat, we've covered that. But what vulnerabilities or inherent risks have been identified in relation to the legal profession?
Sure. So I think we did this on Tuesday, and I think it was quite a little bit before we actually understand what that question fully means. So if I may, what I'm going to do is just take a step back, and I want to just set the scene of what it looks like. Sorry, can you hear me clearly?
Yes, yeah. Yeah, okay. We can hear. Thanks.
What it looks like when we set the scene of an accountable institution such as, legal professionals, and setting their scene for compliance with FICA in terms of what we call our risk-based approach. And I know we throw the term around, quite regularly, but, I find that there's a lack of understanding with clients as to what a risk-based approach actually means. So just to take it back, previously, prior to 2017, when FICA was amended, we previously had a strict rules-based approach. And you'll recall, to those who were compliant, that there was, regulations in terms of guidance notes, setting out exactly what kind of documents you should be asking for. If you have an individual, you need X, Y, Z, certain amount of time for documents to be usable and the like. And what we saw is, when you adopt a tick box approach, that it's not necessarily the most effective. And what the 2017 amendment sought to do was to change a rules-based approach to a risk-based approach. And what that actually means is you decide, based on the size, complexity, and the business your institution carries out, what does risk actually look like for you as a law firm, as an attorney, as an accountant? What does it look like for you? So a risk-based approach ultimately requires all accountable institutions to understand their exposure to money laundering and their exposure to terrorist financing risks. And that kind of brings us on to the next point. We so commonly throw around the terms money laundering, terrorist financing. And, you know, often we think, well, what does that actually mean for me? What does that mean in my practice? Practically, what am I doing with that? So if I can just summarize it very, very basically, money laundering is the manipulation of money or property or similar so as to disguise its original true source. Terrorist financing is the solicitation, collection, providing funds, providing other assets with the intention that it may be used to support terrorist activities. Okay, so we've got that down. What does money laundering and terrorist financing risk mean by definition? But then we need to apply that. And basically what we're looking at is the likelihood and impact of money laundering and terrorist financing activities materializing as a result of the risks we've identified actually manifesting. So we need to look at those specific MAL. So for attorneys, that looks like a lot of things. It's in the products we offer, it's in the services we offer, it can be in the delivery intermediary, are we using an estate agent, are we facing our clients face on? It can do with geographical areas. Are you dealing with someone in a high-risk jurisdiction? Are they in a sanctioned area? And of course, the biggest one for us in the legal profession is the clients we face. You know, in other accountable institutions, such as banks or asset managers or similar in the finance industry, it could be more related to their products. You know, do products provide some level of anonymity to a client? But for us, it's generally who we're dealing with. Are we dealing with natural persons, corporate persons, complex vehicles? Are there certain layers of control that are being added in? Are there unnecessary levels being added in that aren't required? What products and services do our clients offer? So it looks different for different industries, but for us, I think there's a key focus on who our clients are. And just while I'm going through this, I'd really stress, and I know the other speakers have already, that it's very, very important that we look at FICA and its sections, also together with Guidance Note 7 as issued by the FIC, as well as, and Ashley had brought this up in our last session, PCC, Public Compliance Communication 53. And what that does is that it deals with non-designated financial institutions such as law firms. So what I'm going to kind of speak through more generally can all be found in Guidance Note 7, PCC 53. It is all there. The point is just to go look at it. It's very thorough, it's very descriptive, so you aren't left navigating things on your own. We are all in this together trying to navigate it. So if I can just go back then to understanding what our risks are. Now we go, great, we know what our risks are, now what do we do with it? And what we are required to then do is to apply a risk rating. And that means that you're applying a different level of risk to certain identified categories of clients. And what's really important to bear in mind here is that things like risk rating, identifying your money laundering risks, etc., is something that is not static. It's permanently changing, it's permanently moving. Your clients change, your services can change, the industry can change. So it's very important to bear in mind that this isn't a static process and it needs to be updated regularly. So how you do a risk rating, and I know for lawyers, myself included, we see kind of heat maps, and it's high risk, low risk, and it's orange, red, green, and it can be quite daunting to look at. And what I can say is that aside from the fixed guidance, is that there is extensive international material out there to help clients develop risk management frameworks for all accountable institutions, and there are multiple service providers that can assist with that. So we identify our risks, we know what our risk rating is, and now we have to look at managing and mitigating those. It's often we hear those terms, manage and mitigate your risk, and we go, well, yes, I'd love to, but how? How do I actually manage and mitigate my risk? And to kind of break that down, it's a lot of aspects for a financial an accountable institution to do that. But one of the key ones, and you'll hear this term thrown around also, is your customer due diligence. It's monitoring your business relationships. And like your risk rating process and identifying your risks, your customer due diligence and managing and mitigating your risk is a fluid, non-static process. And it really requires constant effort to ensure that you're doing all that you can to ensure these risks don't materialize. So with that kind of in mind, we then have aspects of customer due diligence which become more complicated, I suppose, because you can't just apply one level of customer due diligence. We have enhanced due diligence, simplified due diligence, and those terms can also sound quite daunting. And really all it means is that when we identify a risk, we use our heat map or whatever risk methodology or matrix. Higher risks means enhanced due diligence. What does that mean? What is enhanced due diligence? What does that mean versus standard due diligence? And really, again, it's going to be specific to your entity. It's specific to your needs, your clients. It could mean more secure confirmation of the client information. It can mean updating documents more frequently. You pay closer scrutiny to the client's activities where there is higher risk. And conversely, where there's lower risk and you know the client, you can adopt simplified due diligence. So that means less information is obtained. It can be less secure confirmation, less frequent scrutiny. And that's not to say there's no scrutiny. It's all relative. So it would be relative to what high risk would be. But it just means it doesn't have to be as severe. You exercise the discretion as an accountable institution to say, okay, when am I applying enhanced? When am I applying simple or simplified? And of course, smack bang in the middle of that will be your standard due diligence. What that looks like is completely dependent on you. You are perfectly entitled to refer back to Regulation 3, I think it's 3A, if that is what gives you comfort in your institution. That is perfectly allowed. So if you take that and you look at what we're dealing with, particularly in the legal profession and what those risks were. Stephen, I think you dealt with a lot of them already, but what I'd like to kind of just, I suppose, encapsulate is there are obviously multiple risks that have been identified for the legal profession. And as mentioned already, we've been earmarked as highly vulnerable to money laundering and terrorist financing. And it's really important to remember that we have been obliged to comply with these requirements for a number of years. So it's really important that everyone gets on board as soon as possible, as already mentioned, and to ensure that they have risk management compliance programs in place. So in terms of, the kind of specific risks that were identified by the FIC in the assessment report that I'm not going to repeat, but like already mentioned by Stephen, our services make us particularly vulnerable, and that's our services and our products. As I've already mentioned, our client risks, and whether that's already like your foreign prominent public officials, your domestic prominent flags that you need to know relating to PIPs, PEPs, FPPOs, DPIPs, that is all set out in FICA, the regulations, and the guidance notes. You are not left floundering to wonder, who is this person? How do I identify them? It is there. The guidance is there. And it's a lot of information to take in. But once it is in a single document, such as your RMCP, it does make the content less overwhelming. So aside from your client risks, we have transaction risks. As Stephen already mentioned, we've had crypto assets thankfully brought within the purview of FAIS, which really does lower risk in that regard. But what was also identified in that assessment report was that cash transactions in law firms and the legal profession is very high. What I would just like to add, and I'd failed to mention this in Tuesday's session, is that the cash threshold reporting threshold has actually been amended. It is no longer 24,999 Rand. It is now 49,999 Rand. Equally, the days to report is no longer 2, it is 3. If I am speaking out of turn, please correct me, Ashley, but I just wanted to note that to everyone. There are risks in terms of delivery channels and, again, geographic risks that I already discussed. But what I'd really like to hone in on, and this would need to be covered in multiple sessions, but I think just for purposes of now, it's just very important that everyone understand the reporting risks. As Steve already discussed, that our reporting levels are extremely low. And what it may be indicative of is that there is a limited understanding of our risks in the sector. And that really speaks to what I'd already just, kind of introduced with. How can we be expected to report risks when we don't understand our risks? That's really the foundation of how you can even get to the point of submitting a report to the FIC. It's very important that accountable institutions understand what a risk-based approach is and how it applies to their business. That's extremely important, or else we're just using these terms and throwing them around and we don't know how to apply them. So the most important one I would find, I think that cash transaction reporting is relatively straightforward to understand. But I think with suspicious transaction reports, there seems to be a lack of understanding, and this is accountable institutions as a whole. I wouldn't say it is specific to the legal profession in the least. There's a lack of understanding of at what stage am I getting a sense of discomfort? When am I getting apprehensive? Or when should I be feeling mistrustful with this information I have or with this client I'm interacting with? Is this an unnecessarily complex transaction? Should this trust be here? Is there something behind this corporate vehicle? So it's also about becoming comfortable with what red flags you need to look out for and how those look for you. So in this regard, and again, Stephen had mentioned this, that there are multiple red flags. There are red flags in the assessment report done by the FIC, applicable to law firms. There are red flags in terms of PCC 53, which I mentioned, Guidance Note 7. And what's really, really fantastic, and Ashley had mentioned this on Tuesday, is that what's great about PCC 53 is that it's specific to non-designated financial institutions, such as the legal profession. It may or may not mean that your RMCP looks different to what is required of bigger, more complex structured institutions. And PCC 53, to the extent you haven't seen it already, has a fantastic template of what you can use as a base for an RMCP. And of course, it is a template. It is not meant to be relied on as is, but it is absolutely incredibly helpful. It actually gives you proposed wording. It gives you examples, so you can actually understand and practice what it would look like. If you are to look at FICA on its own and to see section 42, A to S, what is required, you'll find that there's a skeleton, but not a lot of meat on the bones. And you ask yourself, this is telling me what I need to include, but I don't know how to include it. And that supplementary guidance and legislation from the FIC is incredibly helpful in that regard. So I think really, in terms of risks facing the legal profession, and I would say it really is applicable to many accountable institutions, is really a lack of understanding of what we're dealing with. And that's why it's so important that we have seminars like today, where we start engaging with each other and starting to learn together, what does this actually mean for us? I think once we get a handle of what it is we need to be doing, I think many other risks that we're facing can be lessened. So yeah, I hope in a nutshell that kind of explains where I think we're at as an accountable institution, generally from the perspective of the legal profession.
Brilliant.
Thanks.
Thank you. That was really comprehensive, and I think you answered about 3 questions in that one question up front, so well done. I'm going to hand over to Ashley from the FIC to talk from a FIC's perspective about the implications of grey listing for the legal profession specifically, and to also just share her thoughts on what else the legal profession can be doing to improve its contribution. So Ashley, the floor is yours.
Thanks, Stephen, and maybe just thanks to Kirsten for promoting our guidance material. It is very well appreciated. And maybe also just the confirmation that I look after guidance and awareness, not compliance in general, so don't want my boss to get upset if he gets any feedback. So from a grey listing perspective, I've written some notes here. When I look at grey listing, I think of 3 particular things. The first one, grey listing is a consequence. It's not a consequence because we failed to follow the FATF standards, but it's rather a consequence because we failed to ensure that we had a robust AML and CFT framework. And I think that distinction is quite significant. And I know we know him as Momo. I don't know if he's still on the line. He had mentioned a little bit earlier, and it's not, everything that we're doing is really not a knee-jerk reaction because of the FATF grey listing. It really is, changes that have been in the pipeline that have just been highlighted through the mutual evaluation report. The second one is grey listing is a process. It's a process through our peers where we are subject as a country and also as individual professions to increased monitoring and scrutiny. And this pressure then ensures that we take corrective actions. the last thing that I think grey listing is an opportunity. And I know it sounds really cliche, but grey listing means that as a country we have to focus, we have to prioritize, and we have to work together to make sure that we correct our deficiencies. So to Stephen, to your point then, so why the legal profession, and why are we so, focused on you guys? So if you have a look at the mutual evaluation reports, there's a differentiation between financial institutions and DNFBPs, which is designated non-financial professions, which is where your industry falls within. Now, the MER highlighted 2 particular industries that are doing very poor. The legal profession is one, as well as, then they refer to them as estate agency, but property practitioners. So because of that, there really is a focus on your industry because of the nature of the work that you do, with the air of respectability that comes through doing work through your profession. I know all the risks, etc., were highlighted a little bit earlier. Now, Momo had mentioned from an international perspective, that financial and the economic impact as South Africa as a whole. And the thing is, those things do have a ripple effect. If you are working in an international space, if you've got funds coming offshore, funds going offshore, if you have a client that you're engaging offshore, that enhanced scrutiny and enhanced monitoring from that country could potentially put you in a situation where you really have to go through hoops and hurdles, or, and hopefully not, they might elect to follow a de-risking option. And de-risking means, just like you, if your client is too much of a high risk, you're not going to go ahead with it. And other countries also have that option. If they feel that the risk is too high, especially for your profession, especially because it was highlighted in the MER, or the mutual evaluation report, that could have, serious consequences. I maybe just want to conclude when we talk about grey listing, and you talk about, so what does that practically mean? So in your organization, when you have a high risk client, you apply enhanced due diligence, you have enhanced screening, you have enhanced monitoring. Those clients definitely know that they're probably a high risk, because you really have to put more focus, more attention on them, and more scrutiny. And that's exactly the same thing in South Africa. We are kind of the high risk client for the rest of the world now. So if you think about, all the efforts and concern and risk applied to your clients, imagine that now as a country. Thanks, Steve.
Thank you so much. I'm going to hand the floor to Ricardo just to talk us through just how the money laundering, terrorist financing laws have changed the landscape of the legal professional services. And if you can focus just on the question as to the expertise in the profession, have an adequate number of money laundering, terrorist financing experts emerged? And if you can just talk about the challenge there, Ricardo.
Thank you, Stephen. Look, short answer is no, not really. I mean, we tried to detect the expertise in the run-up to this seminar, and we couldn't really find, a lot of expertise in the South African context. So that is perhaps, I think, because it might be interpreted as a compliance burden. Alternatively, when we talk about risk-based, the concept of risk management is normally within the domain of governance, except in this context, AML and the amendments to the FIC Act, it basically means that it's now smack right in, on the issue of compliance. Firstly, in terms of legal practitioners, but also, broadly, there are compliance-related issues.
Mm-hmm.
What we've seen more recently now with the Omnibus Bill is that a couple of laws are being changed, and that are so relevant to legal professionals. I mean, our mandate is to interpret laws and to advise our clients. So when we look at the laws that are being amended, it's the Companies Act, Trust Property Control Act, the NPO Act, and that I can't even get all the names. You impressed us with the long names, man. I'm not so impressed with that. I'm more impressed with the advice in Mauritius. I mean, who wouldn't like to go there to provide? but you're clearly one of the experts in this field, Stephen. And I think there are opportunities in this particular field. It's now part of law, and it's going to stay part of the legal system. And so, as legal professionals, we don't we shouldn't only see it as a compliance burden, but we need to, present ourselves and position ourselves for the opportunities. We're talking about risk-based, and the King 4 report, when they talk about risk, they talk about risks and opportunities. Inevitably, there are opportunities as part of, when we deal with risk management. So we have to discipline ourselves to not only see the risks, but also to look at what are the opportunities for our profession. The risk now is that they're saying, our profession is vulnerable. We're at risk, right, as a profession. And so we need to beef up our participation and our contribution in terms of, this particular legislative mandate. But also keep in mind that in terms of law, as it's been indicated now, that the practice must have the risk and compliance management program in place, right? So if you don't have it in place, then your practice is at risk, unfortunately. But we have to look at what are the opportunities if we do have those systems in place. By implication, I think, if in our practices we focus more on ensuring that we are on board with our compliance responsibilities, we, by implication, are also able to signal to these fraudsters and opportunists that, look, in this practice, you're likely to be exposed. And you're likely to be reported on if you try your luck in our practice. And I think that's important for us as practitioners, in that we change this perception about the profession being at risk. So we all have a role to play. I mean, if you look around the table or around the room, effectively, I think all of us are in a position to become experts in this field. It might not happen overnight, but this is fairly new. According to the MER, the Mutual Evaluation Report, they're saying the risk-based approach is new. So there's still a lot of room for us to develop and also to hone our expertise in this field. And I think, Stephen, I want to emphasize that there's a lot of opportunity in this field. But if we're antagonistic in this regard and we see it still as a tick box exercise or just a compliance obligation, it may effectively impede our ability to see opportunities, for our practices. So I'm quite excited. Thank you.
Thank you. And you've also answered a number of questions just in that one answer, Ricardo. But I think what you're saying is it's not we shouldn't be seeing it as a compliance burden. This is the future. It's here to stay, and we will be supervised. You will be inspected at some point. So get the program ready for that and seize the opportunity. I was going to share with you, we seized the opportunity when the asset forfeiture legislation was new and we started seizing assets of drug dealers, etc. And I was at one of the drug dealers' homes in Cape Town, Stikland, Kiam Rehnquist, who was the biggest mandrake smuggler in the Western Cape. And I realized we need to improve our risk management. Just going back to your comments around risk management, because here was a lawyer and 2 accountants armed with notepads and pens. And then I looked around us and we had the drug unit of the police and they all had Kevlar jackets and machine guns. And then you realize this is actually way out of our normal danger zone, because they said, Mr. Powell, we want you to line up against the wall when we go in so that you're not in the line of fire. We bought bulletproof vests that week. But the asset forfeiture unit slowed down, but I wanted to share that funny story just with the risk management. And that's what this whole session is really about. We've got to think about the risk, make sure our people understand the risk. I'm going to ask Ashley just to give some thoughts just on what else the legal profession should be doing to address this, just from the FIX perspective. Are there any thoughts on that you'd like to add?
How much time do we have? I'm only joking. So it was clearly highlighted in the MER certain areas of weaknesses, and very quickly it was a very poor lack of understanding of risks and it was an inadequate application of an RMCP. And part of RMCP talks to everything that we've been speaking about today. So that's kind of what the report highlighted. I know the problem added to that has been the oversight over the industry over the last couple of years, and that kind of ties in with a recent legislative amendment that's pending, and that's the changes to Schedule 2 of the Act. So currently, I'm not too sure if any one of you have been visited by one of the FIX inspectors. Currently, we have an MOU in place with the LPC where we go out and do the supervision or the inspection. But you're smiling. Someone's nodding their head and they're smiling for those of you online. So I'm sure it was a good engagement. Okay, I don't think so because there's murmuring. But when the Schedule 2 changes do take effect, then obviously that MOU is not really necessary anymore, and the FIC is now going to be officially your AML CFT supervisor. And that's quite important because we're not going to regulate anything else other than your AML. So along with that obviously comes an obligation, being part of these awareness sessions, having our own outreach sessions, and the two things that we're really going to be focusing on, whether it be through these outreach, whether it be through media publications, and also through your inspections, through maybe thematic reviews, is really going to focus on, do you understand risk, and do you understand how to actually implement that in your organization through an RMCP? It's all fine and well to have the document, but if you don't actually know what it means and how to apply it and what your risk is at the end of the day, then we haven't done our job as a supervisor. Now, how are we going to practically do that? Obviously, we are looking at upstaffing or upskilling at the FIC, which in itself is also an MER finding. I want to say we didn't come out of it clean either. There's a lot of work we need to do as well. And part of that is also applying a risk-based approach. So, you have to practice what you preach. And part of our responsibility then is to have a look at our entire database and from, all the legal professions, also take into account the 5 risk factors. We also need to have a look at who you are, what your products are, what geographies you're in, what kind of distribution channels you have. And based off of that, we're also going to make an assessment. Off of that assessment, that's going to guide us to see who is priority, who do we need to see first, who do we need to help the most. So it really is a full circle issue. The last, sorry, Stephen.
No, go ahead.
The last thing that I wanted to mention, just in terms of opportunities, is with this high risk and low risk thing that Kirsten was also speaking about, it's not just a thing, it's not just a suggestion, it's what the Act says you have to do. And the opportunity that lies there where previously with a tick box approach, we used to have guidance note 3 and 3A that told you this is the list of documents that you need, this is the certification requirements. That's been done away with. We don't have those hard and fast rules. What we do have is a minimum criteria. We say you need to know your client. What does that mean? Obviously your risk, have a look at your risk factors. Off of that, then what kind of information and documentation do you need to obtain? And the Act is very clear and it gives you the minimum requirements. The opportunity comes in there is through your risk assessment, you determine what information is going to be sufficient. You determine what information is realistic. If you want to go visit a client face-to-face, if it's a high-risk client, that's perfect, if that's what you've put into your RMCP and if that actually manages your risk. So there's a lot of opportunity in terms of flexibility. It's no longer rigid. You can decide on the documentation, etc. And that's me.
Thank you. No, that was very helpful. Kirsten, can I just check in with you online and just see if there's any other advice, what else can practitioners be doing just to ensure that we are compliant and that we are addressing the money laundering and terrorist financing risk? I know you did highlight some of the KYC, CDD requirements. Is there anything you want to add or emphasize?
So I suppose it would be related to what we've just been discussing on CDD, and I find that for the profession generally, when we're applying these rules, it's very difficult, especially with existing clients, to kind of explain to them the shift in our approach. And sometimes it does come to clients that we're being a little standoffish about it, a little bit obstructive, that we're putting in measures in place that might seem to be, don't make sense to them, especially when you're dealing with certain offshore clients. FICA obliges, for those of you who aren't aware, that, natural persons, we obviously for every client, as Ashley's mentioned, you need to identify and verify. Your discretion is how you do that, but the minimum requirement is that you identify and verify. However, But when we have outfits that are not natural persons, now we have legal persons, trusts, partnerships, FICA imposes an additional layer that needs to be carried out. And that's that you need to know, and I just use this in the most easy way to explain, is we need to understand who the warm body is behind an entity. And in practice, that becomes a tricky one. A lot of clients become sketchy about why do you need to know who the ultimate beneficial owner is? Why do you need to know these shareholders? And you can actually lose an instruction over it. So what I can really suggest in practice is that it's a really good opportunity to make these requirements known upfront. Make it known to the client that this isn't us being obstructive. It is not a self-imposed requirement. This is what we are required to do in terms of law. And if that had not been the case previously, that we imposed this requirement, it is certainly, what needs to be done going forward. And I think if that can be managed upfront with the client, that certainly makes handling the instruction a lot easier. I mean, we have had situations where, and it applies to the profession generally. The nature of our profession is such. I need the advice yesterday. KYC is seen as an admin function. That cannot be the case. That's not. KYC comes before anything else. The advice cannot reach the client if you don't know who you're dealing with. So really, I think it's an opportunity to really get those processes right up front, to realize that it's not, some sort of administrative function. This is a key function to our profession and to all accountable institutions going forward. And I think if that can be managed upfront with the client, that'll make the engagement far smoother, and that we can actually just get that out the way. And if it means that client cannot be a client, that also needs to be dealt with, and dealt with accordingly and appropriately. And, as Steve mentioned, it can be very difficult to walk away from a mandate where a client has said, I would like to put X amount in your trust account, and you have to turn that away. So it's a lot of things we now need to start grappling with, because it's no longer, it hasn't been for a while, to turn a blind eye. That just cannot happen. So yeah, I think if the industry can start wrapping its head around that, I think we'll be in a good position going forward.
Excellent, thank you. That was also very insightful. Thank you. I know in some of the work that we do due diligences on potential targets, acquisitions, transactions, and we try to find out as much information as possible. And sometimes the shareholding information is not readily available if it's not a public entity or listed entity. So you've got to ask the questions. And sometimes you get the resistance where they say, sorry, that's confidential, we're not prepared to disclose. Those are going to be deal breakers, because if they won't disclose UBO, you're not going to comply with your risk management compliance program if you then proceed. So you need to explain, and I think Kirsten, you made a very useful suggestion on explaining the requirements, that this is not us, we're not being difficult, these are requirements that we have to fulfill. And I just want to ask the question, if any of you have dealt with the offshore law firms when they send instructions from abroad, I don't know if you've had to fill in the questionnaires, but we fill them in, and I often help filling in the questionnaires, but they want to know every last detail. And so they've already gotten into the discipline of this risk management process, and we need to embrace it here in South Africa to close these gaps and show the world. And you heard the comments from Ashley around supervision and the role that the FIC is playing. The big criticism is that these professions, NPOs, the non-designated financial institutions, jewelry businesses, diamond, gold sellers, they're not sufficiently supervised. So these are all changes that we need to implement as a country to close these gaps. Can I just ask, Ricardo, the challenge always is the smaller practices. What happens when you're a one-man band or you're a small practice and you can't afford to appoint someone to a compliance role? How does the smaller practice manage this?
Yes. In fact, Stephen, as I mentioned earlier, about 13,000 practitioners are either sole practitioners or solo practitioners or small firms, right? And I'm just reading a question or comment that the vast number of practitioners, and this is from one of our committee members as well, Ilan Lax, he says, I think so, a vast number of practitioners are small practices that are generally low risk. A simple compliance risk assessment framework as a starting point for the client due diligence would be extremely helpful. And we completely agree with that. It would be extremely helpful. In fact, that's what we've provided as the LSSA. But the reality is that not a lot of firms are aware of that, even though we try to communicate that through our various platforms, the website. And you know, as the first item on the to-do list, I would really ask you just to share that with the other practitioners on your networks, whether it's mailing list or, you know, online. The reality is that we don't want practitioners to be in a position where this very polite lady and her team are asking for the risk and compliance management program, and the practitioners say, but we don't have it. I mean, we don't want that. We at the LSSA would like to prevent that at all costs. That's why we've actually developed guidelines for legal practitioners and especially the smaller firms. Now, the reality is that once you're a practicing legal practitioner, you are required to produce that in terms of law. We don't have an option. I mean, we must do that. Right, so we just have to settle that reality. But if you don't have it in place, then you're at risk. Not only are you at risk as a practitioner, but you know, the public is also at risk because Tony indicated earlier this week, we as the LSSA are doing this not only for the profession but also for the public. It was indicated earlier by Momo Mead that, I mean, they're not doing this primarily for FATF. It's for the country. It's for the greater good of the country that we're doing it. So we are mindful of the fact that smaller practices are, I mean, it requires some work to implement it. That's just the reality, but we have to comply with that. We try to make it easier as the LSSA, but there's a principle that I've picked up in the guidelines published by the Mauritius authorities. They're saying basically three things in terms of a risk-based approach. Firstly, flexibility. Secondly, effectiveness. That's quite important. So even, you know, you wouldn't necessarily, as a small practice, have the most complex and complicated program in place, but if it's effective, that's important. And then also, it must be proportionate to the risks, you know, that the organization or the firm is exposed to. So, if we have a firm that is, you know, working or a single practitioner, your assessment is that your clients are generally low-risk clients. You've perused the red flags, the high-risk areas, and if that's your assessment, then the controls should be proportionate to the profile of your firm. Now, obviously, there might be some exceptions to the rule, but the reality is that you don't want to turn your clients into, suspected terrorists. That's not the aim of this exercise. It's to introduce a risk-based approach. So from that perspective, as the LSSA, we also committed to not only stop at the provision of those guidelines, as Tony indicated earlier, our executive director. We committed to assist the profession, and so we will engage in further training initiatives. This is part of this process. We also will issue guidance and also having these question and answer sessions. And thank you, Stephen.
Thank you, Ricardo. And I must say the guide is immensely helpful. I always joke, I do a lot of anti-corruption compliance, and we help corporates to build compliance programs. We've got a challenge at the moment because we're helping one of our utilities to rebuild the compliance program, which hasn't worked very, very well, but hopefully we'll help to keep the lights on. But when we do these types of programs, there's often a lot of pushback. People are resistant, and my advice is really embrace the program, embrace the process. It is part of the future way of working for our profession. I'm going to hand over to Ashley just to add some thoughts from the FIC on what Ricardo was conveying.
Thanks, Stephen. So I agree 100%, Ricardo, and I think it's important to note that the FIC isn't ignorant to the fact that you have very large organizations and you have very, very small organizations. I think at the FIC we call them the big ones and mom and pop shops, and we realize that. And the guidance that has been spoken, and I know we have guidance and you have guidance, and our guidance isn't competing. I think it's amazing that you look at it from a very specific practical angle, and our guidance is more general towards non-financial industries. So I think the two products together can work very well from an implementation perspective. But what I wanted to say is off of the back of that, understanding that there's different risks associated from a financial institution perspective and a DNFPP sector, that's where PCC 53 came into place. So it does have a template, it does have to be amended, etc. And the reason why we put that in place is for those smaller organizations. And if you read the objective of the PCC, it very clearly says this is not for a bank. This is not for a large attorney firm. This is not for a large complex structure that has, international branches, etc. Because they have departments of people who earn a fortune who can do this for them. This product really is for those of you that don't fall within that, doesn't mean that you're not sophisticated, it just means that you don't have access to those systems. So that's the point behind PCC 53. We also do have quite a lot of free material. So when we're talking about, you need to do searches, when we talk about the risk factor of geographic risk, or we talk around the risk factors of politically exposed persons, or from a screening perspective, from a sanctions perspective, we're not saying that you have to go out and buy a system or that you have to get access to a system. This can all be free searches. So a shameless plea, if you ever have a thought around, I wonder what the FIC says about sanctions, go onto our website. We have a PCC that discusses all of these things. And in those PCCs, there's multiple links to free platforms that you can then access. Again, because we are aware that not everyone has access to these funds. We also on our website have a screening tool. So earlier, Momo was talking about the changes to POCTA-TARA. It's quite a significant change for us because there's two parts of that sanction regime. One currently sits under the FIC Act in terms of 26A, and another one sits in terms of Section 25 of POCTA-TARA. That doesn't really make sense because it's split, it's protracted, you have access to one list and not another list. So the point behind that change is to bring the full sanctions regime under the FIC purview, and then you have access to that database on our website that's free of charge. So we really are doing our best to provide free resources. I think I'm losing people here. Then the last thing that I want to mention for sole props. So the Act specifically does refer to a situation if you are a sole proprietor, and that is in Section 42 capital A, and that talks to who needs to be responsible for compliance. So even if you're a sole prop or if you're a large organization, you still have to have an RMCP. Ricardo was spot on with that. The question around who is responsible for compliance, who has to be your compliance officer, do you have to appoint a separate person? If you're a sole proprietor, you are the compliance officer. All right, and then it's on you. If you feel that you don't have the capacity and you need to get assistance and you want to outsource certain functionalities, there is a PCC on that as well that talks about outsourcing. So you can never outsource your obligation. I know it's shameless, right? You can never give it to someone else, but they can assist you with certain things because we are aware that the speciality doesn't necessarily sit within the accountable institution itself.
Thank you. We're going to close the panel discussion and we're going to open up to the floor and to online for questions.
Coming back to the RMCP, okay. Initially when we had to start reporting on FIC and whatever, we never had an RMCP. We ticked the boxes and that was it. It was basically myself and one manager from our risk department, and we did what we thought was necessary. We used to get a lot of flack from our upper echelons, the CEO, the FM, and all of them. How can you do this? How can you ask that? Today, we have an appointed compliance officer. I have my risk department, myself, and my branches, and we work together as a team. And we constantly look at our RMCP. And once you've got it in place, I promise you, it is easy to work. We're in a different category altogether. We only deal with natural persons. So I don't have corporates and all this sort of stuff. But when we look at it and we get different cases arising each and every day, and we refer them to our RMCP, and if we see, hang on, we need to change it, we change it. And today, our CEOs, our CFOs, our COOs are like puppies in our hands, I promise you. Because of our doggedness, and this is, we here as the FICA people and the compliance to make our company easier to trade with. And yes, you're going to get flack from your clients. Believe me, we deal with it day in and day out. Why must I do this? Why do you want FICA documents? Why this? Why that? It does work. But I still have the bone to pick with you about the other part, okay? But that's my 2 cents. Thank you.
Thank you for the comments. It's probably the first time someone's ever started with a compliment, so I'll take it. What I do want to say specifically when it comes to, I think you referred to them as the upper echelons, the Act is very clear around who is responsible for compliance. And previously, before the 2017 amendments, I was a compliance officer myself. I was very scared. I'm not going to lie. If someone came in and I didn't fill in the right form or I didn't have the right documents. But I'd like to think that that's really not where the supervisor focuses on. They want to focus that you understand the framework, and if your framework is correct, then obviously you are going to have the correct documents or information in place. What I do want to say is the compliance officer no longer is that person who's responsible. In fact, we don't even call it a compliance officer anymore in the Act. We call it a person responsible for compliance. And this is a person that the senior most management or the board has to appoint, because they are ultimately going to be responsible should anything go wrong. So I think that shift in dynamic, I think you spoke about it on Tuesday, the tone from the top is very important, and I think that the way that the Act is structured really does facilitate that. So I'm glad we could help in a small way.
Thank you. And Ashley, if I can just seize on that phrase, tone from the top is so critical. And for all of us here, one-man practices, small practices, you need to set the example and show your staff members, your team, your administrators, your accounts department that this is something we're committed to. And we need to get that education and message across the board. And we need more tone from the top, and that's why I'm so pleased with Tony and the Law Society for initiating this type of awareness, because tone from the top comes from Tony as the acting CEO of LSSA, and there's commitment from his board above him. This is something we've got to really reinforce within our practices. Thank you. And also heartening to hear your positive comments. So that's just to soften Ashley up for what is coming. So can we go to the next question?
I've identified a risk. The risk is that the legislation and its implementation just goes a step too far, and it threatens the very existence of the attorney's profession in the future, because under threat of immense fines and or criminal prosecution, the attorney is now forced to be an informer for the state. Now I make a distinction between ethical and unethical attorneys. If you're an ethical attorney, you will obviously disclose this to your client. If you're an unethical attorney, you are going to lie to your client and inform on the client to the state in any event. Sooner or later, this is going to become public. And that is going to mean that the people, natural and legal, will no longer make use of the services of the ethical attorney, and that will mean the end of the attorney's profession. And no one, since the first FIC bill went to Parliament up until today, has questioned this aspect. And that is the future continuance of the ethical attorney.
It is a difficult balancing act, and I think that's where explaining the requirements, and I think my advice is we encourage all attorneys to be ethical and to understand their obligations and to convey the requirements to their clients so that the client does not get upset that you've secretly reported. We've got to balance these requirements and make sure that we do the right thing, and it's not always easy. So these are the challenges that we face. I'm not as skeptical. I don't think it'll lead to the mass destruction of our profession that you fear. I think this can be managed. And it's part of the way of doing business. So we spoke earlier, this is not unique to the legal profession. It applies to all professions, all companies, all corporates out there. And we are vulnerable, and we've got to be doing the maximum we can to address the risk. Ashley, I can see you raring to go.
I'm scared. So, I can't answer that strategic question. I appreciate the question. I think some comments that come to mind is we can't not implement legislation because we're worried about those people who don't apply the law. What we do, however, do, and that's part of maybe the background work that industry doesn't see, is as much as we go out to, as part of our supervision, to check that those who are being compliant are following the rules properly, there's also a very large drive to find those who are in the net who have just decided that they don't need to comply with legislation. So oftentimes what we have through our MOUs with the likes of the LPC and the other supervisory bodies is we often get databases to compare. And when we do that comparison, either we have people registered with us and not with the legal profession and vice versa. And when that takes place, then we go and find those individuals that are not registered with us as the FIC. And then there's another drive to get them to register with us. Once they're registered with us, then obviously then we can go out and do a full supervision on them. So it's not, we don't ignore those people who decide that they don't belong. The second thing that I just wanted to mention in terms of STR reporting, and I think the gentleman at the back asked that question a little bit earlier, there's a reason why, and Momo did touch on it, there's a reason why you don't get feedback from the FIC, much like you're not allowed to let anyone know that you've submitted an STR, and you're not allowed anyone to know the person that you submitted on or the content. And not just the person who is being reported, but anyone else, because it is that confidential, and the fact that there is an offence called tipping off if you do let someone know about that. There's a further provision in the Act that says when this information comes through to the FIC, remember we're not an investigative body, we're a data gathering body and we're an intelligence generation body. So what that means is we receive all the information, we connect the dots, we look at the information from you, from a motor vehicle dealer, from a bank, and how that all connects, even things like cell phone numbers, postal codes. And there's a reason why there's certain information in a report, because all of that information gets analyzed and we can do, it's very impressive, the diagrams and the connections that gets made. That intelligence then gets handed over to law enforcement agencies and they need to do what they need to do. What is important is our Act also protects the reporter. So it's not like, and I can't compare with whistleblowing because I don't know whistleblowing very well, but from an STR perspective, you do not have to testify in a court of law should you not want to. Your information is protected. So they're not, the person who's been reported is not going to know that you were the one who submitted the report. The bank could have even submitted it because think about it, your Fidelity or your trust account is held with the bank. So the bank, if they see something suspicious, they're going to report. So it can come from multiple angles, this information. So no, it doesn't address exactly the issue. Yeah, you're saying no, but that's the answer I have. Or the input I have, not the answer.
Just before I made Tony volunteer to answer some of the question, he offered to answer some of this.
Thanks for the question. I've attended all the FATF reviews since the first one, representing the legal profession, myself and a lady called Maralise. And from day one, we've always insisted on the professional legal privilege. So as an attorney, professional legal privilege still remains. STR reporting actually answered what I was going to say. It's just an indication that there might be. It is not reporting that there has been a provision that has been superseded or exceeded. It's just an indication. In the beginning, the FIC said to us, attorneys are reporting too many matters, right at the beginning. Actually, you weren't there. But an attorney just, what the default position was is if we don't know, we report. So then we had a meeting with the FIC to say that's the reason why they're reporting. They don't want to be, and I want to give the right words when Ashley spoke about who is actually, it's the accountable person is the most responsible person, is the responsible person. The other person that you delegate to is responsible to carry out your instructions. But as the practitioner, you are individually identified as a accountable institution. So you carry, or your board carries the accountability. At the end of the day, they are accountable for non-compliance, not the accounting officer or an accountable person that was appointed. So as far as professional legal privilege is concerned, that is covered. What is not covered, and that's even in the legal ethics, is if you conspire with your client to break the law, and even in your normal engagement, that is part of the difficult thing when we train legal ethics with candidates, and even we do it, is we explain to practitioners and candidates, you cannot willingly break the law. You need to recuse yourself when your client asks you, how do I break the law? I'm putting it very bluntly. You need to recuse yourself. That's your professional ethic responsibility. And so that is how there is a balance. It's not, we even had proposals from committees, from the Law Society, to institute constitutional challenges when we first implemented FIC. And we had people that were jumping. Unfortunately, our chairperson at the time, who's now a judge, he said to me, Tony, I'm removing this item from professional affairs and I'm giving it to you to run with, because the attorney's position was we will oppose FIC from day one. And we built a good relationship with our members, more importantly, and with the center. So what you are talking about is something that has been debated and discussed for a long time. And there is no ideal, and Stephen used the right word, is we found a balance between the two. And it's this, as Ricardo said, I pointed out in Cape Town on Tuesday, this is not only about the profession, it's about the national interest, it's about our country, it's about our people, it's about our economy, it's about our communities. There's a ripple effect that touches everyone. The touch points in FIC, there's nobody excluded as a touch point. So I just thought I'd add that, Stephen. Thank you.
Thank you. That was very useful. And Ashley's got something she just wants to add as well. So thank you.
Just
Thank
a
you,
very,
Tony.
very small thing on privilege. So Section 37 of the FIC Act does cover what Tony says. So it mentions that the reporting of STR and in terms of confidentiality. So confidentiality, whether it be offshore confidentiality or confidentiality principles, doesn't stop you from submitting an STR report except for cases of legal privilege. So if you check 37, it is in there.
To the gentleman just in front there. And then there's another question. We'll come to you next. Thanks.
Thank you. Thank you for the seminar, and it was very informative. I basically would just like to read through a few comments that or a few points that I've noted. Firstly, we appreciate the increase in the threshold to 49,999. The amount was very low, but the 3-day period within which to report transactions is impractical. If you sit in a legal practice, you know, and someone that doesn't have a compliance department, for you to actually log on and answer the questionnaire and fill in the thing, which is actually quite burdensome, having sent reports through, and impractical as well sometimes. There's no assistance there's no point where you can call. If you do call FIC, there's no one to assist you on the phone. So those are things that help attorneys comply, and I think they should be put in place. I think we should have more of these type of workshops, maybe even once a year. Maybe there should be something compulsory, and because I don't think attorneys are quite aware of a lot of what's happening. I see you people use acronyms quite a lot, and I'm quite impressed with the way you people use them, and a lot of them are gibberish to us. The truth of the matter is we read the emails that come through from FIC, we scan through them. No one's going to remember the acronyms, and I think they're quite important to at least the basic ones, to become familiar with them. With regards to, I think there's a fine line between being ethical and non-ethical, and if attorneys could be more ethical, there won't be a fear of loss of instructions. Okay. I think FIC also places a big burden on the legal practitioner. Instead of providing legal advice, we are transformed more into, if I could say, a policing agency. And that ties in with what my colleague here mentioned. And it is a little bit burdensome. And I think FIC has passed the buck over to the attorneys and the accountable institutions to do a lot. If it was a 5-minute report, I think we'd be submitting it quite easier and frequently. But the problem is it takes up to half an hour, 45 minutes to complete that questionnaire. Thank you.
In other words, actually, time is money.
Yeah, exactly. Actually, you guys have been softer than the Cape Town team on the FIC. They said to Ashley, your system is Byzantine, if I can quote, and it's very user unfriendly, and sometimes you fill in all the fields and then you get a rejection because you haven't answered something properly and you've got to start again. The news, I can speak for Ashley, is this. It's not easy, but it is something we need to do. And Ashley, I think the news was that the system isn't changing anytime soon. It is a very good system on the back end. So, Ashley, sorry, I better not speak. I'm not here to defend. I do not represent the FIC.
Yeah, and I'm also not here to defend. I'm here to represent. So obviously, knowing who pays my salary and for the no, I'm joking. So GoML isn't an in-house system. So again, I'm not defending the system, I'm just explaining the system. It's a system that's built by the UNODC, and it's used by multiple FIUs that are part of the FATF network. So it wasn't a system that it wasn't the cheapest one that we secured. It's quite we do pay a hefty price for it, and that's because of the analytics that it comes with. So you as a user see a interface of capturing data. So if you ask me how long it takes to report, it should take you 3.5 minutes. If you fill in the fields correctly, everywhere you see a red star, but I'm saying this as a person who I've gone through the user testing and I've had to try break the system to make sure that the system works. I'm not saying it in an ugly way, but ideally you're right, it shouldn't take you more than 3 to 5 minutes to fill out a form. When it comes to the rejections, and the system is very finicky, I'm going to be honest, I've used it, I know what it looks like. And there's certain areas where we know people always make mistakes. So there's a field called to and from. If you don't fill in to and from in the right way, it is going to reject. So if you realize what to and from means, then that's going to prevent your frustration going forward. There are videos, there are tutorials. I look after the call center, so I'm worried if you say that we're not picking up our phone. It's between 7:30 and 4, but we can always talk after this if you are having serious issues. We've got like a call board, and I have a screen that I monitor every day. It works on a RAG status, so it's a proper call center. It's not the case that one of us, I'm sitting here, so now no one's going to answer the phone. It is up and running, but anyways, but the back end of that information, and I know the form is full. I beg your pardon, the form is long, and if you have a look at the regulations are very specific around the information that needs to be in a report, and if you look at the report on GoML, that maps the information in the regulation. So we didn't come up with what needs to be in the form maps what legislation requires. So that's why it is so long. The reason why also it's so long is that information is so important from an analytics perspective. So if we don't have an address of an individual, if we don't have their 10-digit ID number or a valid passport number, that information isn't going to be that helpful to us. So there's reasons behind the validations. I know it doesn't take away your stress, and I know it doesn't answer the issue, but that's just the way that it is, or why it is, rather, not the way that it is.
If I could say that I understand from where you come, but comply. We'd like to comply. So your system isn't making compliance easy. And if you require us to comply, or the Act requires us to comply, then I think you should provide a system, irrespective of how many authorities use it. I think Cape Town told you quite clearly it needs to be revamped. And it needs to be revamped, no doubt.
No, and I hear you, and I can assure you, I look after the awareness portfolio, and we do multiple sessions. And I would be lying if I said there's not one person that doesn't tell me that GoML is a bit of a pain. So I acknowledge it. I've got colleagues here in the room who are giving me this eye because we all know it.
With regards to the call center, I'm happy that you're directly responsible for it or involved in it. How many times would you think I called the call center during the 3 times I got rejected? And how many times were my calls not answered that I was rejected 3 times? And understand the frustration in that hour or so.
No, fully.
Especially if you've got other things that are more important to get.
More important than FICA compliance. No,
you know, I'll be honest with you, when you've got a fee that you charge for FICA compliance, it's a pleasure FICAing a person.
Yeah.
That we can either condone or discuss now. There were many things that you spoke around. Acronyms, yes, we're very guilty. We love a good acronym. And I can say like 10 like this, and I'm sure in your world you can use acronyms and I'll have no cooking clue what you're talking about. So I know in our awareness, generally what we like to do is we have a list of acronyms that we use, that we tell everyone, take a photo, because we're going to talk about these. And sometimes it's just a tongue twister if I have to talk about the protection of democracy and blah, 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 blah. It's easier to say POC. So, and then I think the last one was around FIC policing and passing of the buck. All I can say there is, again, we're an intelligence generating organization. I cannot create intelligence if I don't have data. And I can't get the data because I'm not at the coalface. So we can't do what we do if we don't get the information, and the only way we can get the information is through reports. And if you look at our schedule, the schedule is very specific. Ooh, it's coming.
Thank you, and you've made some very good points, so thank you. We'll just hand over to this gentleman over here.
So I've got 2 questions for Ashley. I know it's quite a relatively new thing, law firms being audited by FICA. I think it started about 2 years ago, and when a lot of my colleagues tell me they're being audited, they're about to have some type of a breakdown. But I just wonder, out of all the firms that you've audited, have you guys given any financial penalties to any law firms for non-compliance? Because my interaction with the supervisors is it's not really punitive. You're trying to just get us to the right place. So I'd be quite surprised. I know some banks have been fined, but yeah, that's my first question.
That's an easy one to answer. So we have an MOU with the LPC, and then from there we started taking over the supervisory function, specifically from an inspection perspective. Yes. Noting that the profession hadn't been inspected for a good couple of years. Yeah. So I think part of that strategy and part of that rollout, and also in terms of the powers that we have through a MOU, was to start the initial outreach, gauge how the sector is doing. That kind of led to, when we realized, listen, the sector's really not doing that well, based off of the inspection findings, that's when we said, okay, now we need to change the legislation and take over fully as the supervisory body. So when the schedules do change, and we are hoping before the end of the financial year, which is end of March, that we would then come in as a full AML supervisory body, and with that then would come in penalties. There are very specific penalties for specific failings. So the only criminal penalty in terms of, or criminal sanction in terms of our legislation, is failure to submit an STR. Everything else is an administrative sanction. But what I can say is, and you would have seen fines from the banks, we don't issue to that extent, and that's done by the Reserve Bank, because they're the supervisory body and they're the ones empowered to impose that penalty.
Okay, thank you. Sorry, I just have a second question. I think it was Kirsten, the online panelist, said earlier. Can you hear me? I think it was Kirsten, the online panelist, said earlier, like, a lot of us don't really understand exactly what a suspicious transaction is. This is quite new, a lot of it, and mine's more in the context of a bank. You know, if you just have an example, I've got a case at the moment, I won't mention the bank's name, but they had a customer who, from the inception of his account with the bank, had 119 Rand in his account. He declared that he earns 1,500 Rand a month. He gave fake employer details in the Know Your Client list, and he received a couple of millions into the bank account. I think 4,700 times his salary. No one asked him a thing. He then went on a 6-day spending spree. I think 32 transactions, spending 500,000 Rand buying liquor, watches, Versace. No one asked him. So at what point does the bank have to identify what the suspicious transaction is? That when that millions came into his account, or is it after his spending spree? Because I'm sure they'll say that it's technology that works it out, or it's algorithms, but we don't really know, and a lot of this information is hidden from us, even as attorneys. You know, you have to go to court just to get that information from the bank. So I'd like to know, at what point should they have picked up this transaction? Because, yep.
Sorry, we can't
Tony,
hear.
you know,
Sorry.
we kind of have the same concerns. I mean, I know that what we advise clients is it's the moment the suspicion arises in your mind. Now, the question is, at what point are you now going to become suspicious? At what point do you then need to ask, you know, the bank for information? And you're 100% right that, you know, a lot of information is kept away from attorneys. I've experienced that myself, where, you know, a client will perhaps want to have a phone call rather than put things in writing. There are certain things that we are already function that we perform. So what I mean, I don't know how it applies to that example. You know, I'm not necessarily on the front line of experiencing that and when we need to report, but my understanding is that it's, you know, as a reasonable suspicion arises in your mind. And actually, I don't know if you have kind of more practical color as to how we apply that in practice, especially, you know, bearing in mind that we aren't always privy to all that information, but of course bearing in mind that our suspicion is only as good as the information we have, you know, on hand, and our, you know, duty can only go so far. I mean, we're not going to go on a fishing exercise and be digging around. It needs to be a reasonable suspicion, right?
Thank you. Sorry, Ashley, just to sum it up, I want to know, is it an individual or computer working out what's a suspicious transaction?
So it really depends. I mean, if you're talking about from a banking perspective, so we do have a directive in place. I was going to say the acronym, but I'm not going to. It's the Automated Transaction Monitoring System Directive, or ATMS. And banks do rely very heavily on systems, and this is where the risk-based approach comes in and where the two actually work together. So in that particular instance, if I've opened up a bank account for this particular individual, sorry, I thought someone was calling me. And you know that they are a low-income earning individual and they live in a particular area, and you can expect to receive 1,500 Rand every month. That information gets put into their system. Based off of that, there are algorithms that run in the back end. So I know at the banks that I was working at, we would kind of have, we would call it variance report triggers. So if anything over 10% variance triggers on a low-risk client, that's going to flag a potential STR flag for us. That then goes into our system, and then every morning you log in, and that's part of your transactional monitoring, which is an obligation. And then you would line by line going to each profile and see, okay, is this suspicious or not? So there is normally a human behind that process that looks at the data. The system can only flag information. The person generally makes a determination. Then in the back end, what happens is we call it batch reporting, because banks have so many of these flags that come up. They cannot go into a system and log one by one by one. So they would log it into an internal system, and then on a daily run, that batch then talks to our system in the back end. So we do have that functionality with larger organizations that we can receive batch reporting. But in that example, I don't think that was a suspicion. I think that was a fact. And even if it was a fact or a suspicion, it would still be reportable. The question around when, and this is something that the banks do grapple with, so I won't spend too much time because I know you're not banks. The rule is you have to report it as soon as possible. So the minute you find out, you need to report it, absolutely no later than 15 days. It doesn't mean then that you have 2 weeks to submit the report to us. It just gives you time to do analysis if you have to do analysis. In that particular instance, I think that was a no-brainer, and it would have to have been reported immediately.
Thank you, Tony. I don't know if we've got time for any of the online questions. No?
There's no questions. Am I right, Mapula? Okay.
Okay.
We will share the comments with everybody. I'd like to thank every one of you that came today. I think you would leave you knowing a little bit more. But I got a challenge for all of you. Ricardo said that we were trying to find people that deal within FIC law or anti-money laundering law. The challenge is for you when you start implementing processes in your own practices or firms is to become an expert, and then you've got another field of practice like Stephen. So that is one of the opportunities that Ricardo was referring to. You are going to have to educate yourself, so why not make yourself an expert? And the Law Society will offer training, certification, so that you can take it further. Because we believe the more people there are that are informed in the profession, the more knowledge can be shared amongst everyone. So thank you very much. A special thank you to the panelists. I'll start with Stephen. Thank you, Stephen. Ashley, as always, thank you very much. Kirsten is online. Thank you, Kirsten. And then to Ricardo and the rest of the communication team that are with us today. Please go back safely. I did apologize at the beginning. I'll apologize again that we weren't aware about the parking facilities, and last minute, Mapula actually said to me, let's just get Kutso to provide a shuttle service. So thank you very much. And the Law Society is open. We will answer your calls. We don't have a call center, but we definitely will answer. But the end of the day is it will end up by me, and I might pull in Ricardo. But we've got a policy that says that we will respond, even if it's just an interim response. We will respond within 24 hours, and within 48 hours we will give you a response. And that's our commitment to the profession. Doesn't matter what it is. So it's not Ashley's fault, it's our fault, because you're not calling us. We are not the regulator. I want to emphasize we are not the regulator. We're here to represent all of you as attorneys. And the word that Ashley was talking about, I spoke about earlier, we know there's compliance fatigue in the profession. But
Tony,
unfortunately, we have to move on.
Your call is important. You are caller number 495 in the queue.
We don't have that system. It's either Ricardo or I. We've got other expellatives that we use.